May it pleases you, Lordship.
Yes.
Thank you for mentioning item number 4 of daily list, Your Lordship. Your Lordship, extra copy has not been served upon us, for which we are not able to take instruction. Kindly matter may list after 2 weeks. I have taken consent from the other side.
Who appears for the petitioner?
It will serve.
Give them a copy.
Copy will submit.
With the counsel for the petitioner. Write his name. State that the copy of the petition in the paper book shall be served upon. Mr. H.P. Kyle. Government Council. Okay, request. The joint request. Adjourn to 3 weeks.
Your Lordship, GST name may be reflected on the cause list, Your Lordship.
Next.
It was not shown in the cause list.
Next, you file your appearance first.
Yes, Your Lordship. Deeply obliged.
May it please your lordships. May it please your lordships. My lord, as regards to item number 108, my lord. My lord, I pray that this matter may be heard in the next week, my lord. From the week commenced from 7th to 11th, my lord. Item number 108.
Give the details to the court master. Next,
My lord, I beg to mention item number 97, my lord. In this case, my lord, state has, my lord, appellant state has filed, my lord, affidavit in opposition. So I have to file reply, my lord. So 10 days time may be given.
next.
My lord.
May I please, Your Lordship, in this case, we file an affidavit just to bring on record certain documents, copy piece of the incident. Not for the facts or not for any other document of it, the other product of some document.
Yeah, I have to say some 2-3 lines, my lord, I have to make.
May I please, Your Lordship? Item 94, my lord. With the consent of other side, affiliate side, my lord. This matter will be taken on 9, my lord. My senior Mr. K.N. Chaudhary is out of station today, my lord. Take it. 9.
May I please, Your Lordship, with the consent of other side, I beg to mention item number 93. Lordship, kindly, the matter may be taken after 3 weeks, Lordship.
Next.
May I please, Your Lordship? Lordship, with the consent of the other side, I'd like to mention item 106 of the daily list. Lordship, matter may be passed over for the day.
106. 106.
106, Lordship.
CRPF.
Yes, Lordship.
Next.
May it please, Lordship. I beg to mention item number 79 and 80, my lord. I have taken consent of all the sides, my lord. My senior is a person difficulty, my lord. There is a death in the family. May it be listed for 3 weeks, my lord.
My only prayer, my lordships, is if a date may kindly be given.
So date will be given.
Like,
In fact, yesterday also somebody mentioned this.
I also, my lord. My senior Artik Thakoti, I mentioned on his behalf, my lord.
Yesterday you only.
Yeah, my lord. Yes, my lord.
So we are partly apprehensive that it will not be taken. Next.
May I please, Your Lordship? Lordship, on 21st October, I move one criminal against the preventive detention, Lordship. And Lordship directed to list it in 1 week or maximum 10 days. But in the case status, I found that it was fixed on 25th of November, Lordship. I am already in incarceration, Lordship, more than 1 year, Lordship.
Day after tomorrow.
May I hope.
May I please, Lordship, back to mention item number 95, hearing, first hearing. So, my lord, I took consent. So, I need to file affidavit reply against the IA. The IA is to impeach the daughter. So, for this time may be allowed.
No, but anything otherwise in the main matter now.
My lord, actually, it is the order against the Central Administrative Tribunal because decision of the husband and wife. They have decided that she is the wife, opposite party of the deceased husband. So that CAT has no jurisdiction to decide that because trial court, one case is pending, that is sure. For decision.
You want time today?
Type for this time maybe.
Next.
95, 96.
Lordship, in 96, I am the respondent on your Lordship. Lordship, in this case, I need some time to file an affidavit in opposition, Your Lordship.
So both the matters will
Yes.
be together.
Yes.
Yes, sir.
96 filed by the railway, my lord.
Next.
May please,
Macho.
Your Lordship. Lordship, I beg to mention item number 92, Lordship. In this case, Lordship, senior advocate Mr. B.D. Das will appear. today he has some personal difficulties, Lordship.
Next.
The matter may be come after 3 weeks, Lordship.
Next.
Oblige, Lordship.
Item number 1 and 2 of daily list.
Yes, what are your instructions?
Lordship, yesterday evening, I have been given a verbal instruction by the Commissioner and Secretary, Lordship. As per letter of the supplied by the Union Government, Lordship, para 8, regarding shifting to the Jammu and detention camp at Jammu and Kashmir, Lordship. It is the stand of the government is there is no such provision by the state of Assam to shift them to the Jammu and Kashmir, Lordship. But if your Lordship directs, Lordship, then the government may take appropriate steps and with the Jammu and Kashmir government, Lordship. And if the Jammu and Kashmir government allows, then the persons may be sent to the detention center at Jammu and Kashmir, Lordship. This is the verbal instruction given by the Commissioner.
Now you read para 8.
Yes, Lordship. It is stated that the
Let us be very clear at this
Lordship.
threshold.
Lordship,
There is neither a question of overpassing any order,
Lordship,
nor anything is required. Your officers have just telephonically, without application of mind, with greatest respect to them, have given you this instruction. Read the paragraph. Paragraph 8.
paragraph 8, Lordship, yes.
However, Ministry of Home Affairs has no objection in shifting the appellants from so-and-so to so-and-so, provided that state government of Assam and Union Territory of so-and-so coordinate in the matter and also ensure that the person should be readily available for departure. So the instructions which we requested you to take was to coordinate with J&K administration.
Lordship,
It is neither your prerogative to decide. Home Ministry says that they have no objection.
Lordship.
Either you were not clear or your officers are
Yes,
purposely
Lordship.
not clear.
Actually, there is some problem with that means the officer who was actually looking after this matter, Lordship. Yes, there is something was there. So now the file has been moved yesterday only, Lordship.
Whenever it is moved.
So, Lordship, I pray that Lordship, after the 10 days, if your Lordship may take up the
So
matter, Lordship.
tell them that they may not try to teach us anything by sending this type of instructions to you. Let us be very clear. Ask him to remain personally present on Friday. We are not passing any order. Call the secretary home.
Lordship,
We'll explain to him.
Lordship,
It appears that you are not in a position to explain it to him. What is what? We only want coordination.
Lordship,
What you have to take instructions now 10 days. This tour is 10 minutes. And you want 10 days for a person who is in detention.
Lordship, with appropriate, that means the steps they have taken, Lordship. That's why I'm
You
praying.
take
10.
instructions by tomorrow, otherwise day after tomorrow you will be here.
Lordship, day after tomorrow, then, Lordship.
We don't want any personal
Lord-
presence of officers.
Lordship.
You are the assistant.
Yes, Lordship. Day
Talk
after
to him.
tomorrow.
He should come to your office and brief you, the concerned officer.
Lordship.
Somebody, we are concerned with Article 22. You know this is a ticklish issue. Your
Lordship.
officers, with great respect, should take very seriously.
Lordship, Lordship,
And if you fail, ask learned advocate general to assist the court.
Lordship.
These are serious matters, Ms. Bhattacharya. You are a senior counsel.
Lordship, I will place the instruction, Lordship, but day
Don't
after
place
tomorrow.
instructions. We want instructions on this line of paragraph 8.
Lordship,
Have they made any attempt to coordinate with J&K administration or not?
Lordship.
If they have not, then we'll direct them to coordinate. We don't want to throw them away. They are human beings. Take it seriously, otherwise
Lordship.
we will be more serious than necessary. Convey our feelings to your officers. Monday. By
Deeply
Monday, see
obliged.
that this is resolved. Next, at the request of next.
Item number 3, obliged.
We are issuing notice. We are issuing notice.
Obliged.
Next.
Item number 109 of supplementary list.
May please. My lord, the appellants, my lord, they have now faced, my lord, grave hardship in view of the judgment of the honorable, my lord, single judge.
Any other similar appeal is pending?
No, my lord. No, not pending. My lord, what has happened in this case? My lord, there was a projection that the selection and appointment, my lord, of the appellants, my lord, is illegal. And the ground was that the qualification of the appellants, my lord, does not conform to the stipulation of the advertisement. My lord. Now, the advertisement says that the qualification of laboratory technician, my lord, it must be from the state of Assam by recognized institute. At the same time, my lord, it was oblivious of the fact that the statutory rule, my lord, holding the field, my lord, makes another requirement that if it is not acquired from the, my lord, the recognized institute, authentication, my lord, can be given by the Director of Medical Education Assam. And thereby they, my lord, acquire the, my lord, qualification to participate in the selection process. Now, the honorable single judge, my lord, proceeded on the basis of the, my lord, advertisement itself, my lord, missing out this particular fact that the statutory rule provides authentication by the, my lord, Director of Medical Education Assam. And I'll show, my lord, from the facts that there is a deemed authentication by the director.
The question is twofold.
My lord.
The requirement cannot be diluted by any statutory rule. The qualifications which are requisite as per the rule or an advertisement, it cannot be diluted by anybody.
My lord.
A
Absolutely.
rule cannot dilute because ultimately advertisement will prevail. We take it that way. But it should be in consonance with the rule.
Absolutely. My lord.
Now, there are one way of thinking was that maybe you may be having any certificate, then also it requires authentication.
My lord.
Now,
Yes.
we don't find that you have argued this point before the learned single judge.
Yes. This point was not argued. Lordship is correct.
Now go to the memo of appeal.
My lord.
And go to page 15, Roman paragraph 4.
Page 15, my lord. My lord.
Roman
4.
paragraph 4.
My lord.
Now you have framed these three questions. Even in that you don't find.
Yes. Lordship is correct. My lord, these were the
Now-
grounds. Yes.
Appeal may be a technically continuation of the proceeding. But to say that learned judge has committed an error.
No, my lord, I'm not on that.
No. If you are not on that, then the appeal in fact would go.
In fact, what has happened, my lord, pursuant to the honorable single judge order, now the government, even without hearing us, my lord, have passed.
That is a history.
My lord, honorable single judge order is a
Even-
balanced order.
Even in your grounds of appeal,
My lord.
you don't find this ground. Except the fact that you have narrated in the earlier part of the
Lordship is correct, my lord. It's a question of law, my lord.
No, any question you can't just jump and say that it is question of law. It has to be examined in light of the facts of the case.
Yes.
We are not dealing with taxation or excise appeal that you or a second appeal under section 100 of CP. It's not that easy. These are restrictions. Go before the learned single judge and file a review.
Yes, my lord, I consider, well, only one aspect of the matter. Now, what has happened, pursuant to the honorable single judge order, my lord, the authorities, my lord, concerned, without giving any opportunity of being heard, without making any inquiry, there was my lord, a specific, my lord, direction to call an inquiry.
Sorry, that you can urge.
Now, my lord, the service has been terminated.
That
My
is
lord,
a-
we have put in 10 years in service. My lord.
That is a separate cause of action, Mr. Talukdar.
My lord will kindly, my respectful submission is, Lord will relegate us, my lord, to the honorable single judge. We will definitely, my lord, argue that, file a review application, my lord, or whatsoever. But till then, my lord, the termination order may be stayed because
we
we have
can't-
not been heard, my lord.
We can, that you challenge by a step. We need not advise now. Our sanads are already taken away by respective bar council.
At least, my lord, till the
Then we
honorable
will
single judge takes us, my lord, take our cases, my lord. Lord, till then, my lord, Lord, will kindly stay it, my lord.
It is honorable.
Otherwise, my lord, we have changed our position to a detriment.
No,
Last
you-
10 years, my lord, many,
Mr. Talukdar,
my lord.
whatever actions are taken are pursuant to paragraph 30 onwards of the learned single judge.
No, I defer to that.
No,
because,
therefore, they will say so.
my lord.
But you have to rush to the learned single judge. We are not preventing you. You will get the order by 2 o'clock. Hold, Mr. S.K. Talukdar. Mr. Counsel for the appellant and Mr. Principal. Mr. Talukdar, learned counsel appearing for the appellant has contended that the recruitment processes are governed by the recruitment processing is governed by
The statutory rule, my lord.
statutory rules,
Assam Laboratory Technician Service Rules 2012.
name the rules, and the state rules inter alia provide for authentication
My lord.
of a certificate of experience,
My lord.
experience certificate,
Qualification, certificate of testimonial, qualification, my lord.
testimonial.
My lord.
It appears that the state point was not raised before the learned single judge, which is
My lord, there is another ground.
admitted by
There is a provision for relaxation. My lord.
that is Mr. S.K. Talukdar and counsel candidly admit that the state question was not raised before the learned single judge. And full stop. In view of the aforesaid, Mr. Talukdar takes permission to approach the learned single judge by way of a review application
My lord.
and does not press this appeal at this stage.
My
Permission granted. This disposal of this appeal shall not prejudice the rights of the party. The
Well,
learned
but-
single judge shall decide the review as expeditiously as possible. Next.
My lord, another ground, Lord, we kindly add, my lord.
No,
I-
you
my
can
lord.
say.
Obliged, my lord, deeply obliged.
Next. As the appeal is disposed of, the I have to take the. Okay. Is there any progress? What? Who is the advocate? They all know that it's take up its scope. Next.
Obliged.
We have taken steps. We are waiting the service report.
Give it service. Give the day. Mr. Majmudar, by the way, you are here. What have we to do with those provincial
Provincial election cases, my lord. We are we have been instructed by the secretary, my lord, that an extended committee has been formed to look into all the old records of the. We have
But
we are
when,
praying
when
for
shall
around
we have
4
the
weeks.
report?
My lord,
When shall we have the report?
my lord, they pray for 4 weeks, my lord. I have got
4
the
weeks means you come at 2 o'clock in presence of all the party.
Right.
Next. Yes.
Look, this is with regard to, my lord, removal of unauthorized religious structures from public places. Pursuant to the, my lord, order passed by the Honorable Apex Court. My lord, so far as state of Assam and other states are concerned, they have worked out substantially to remove those portions, religious structures. But
Mr. Das, did you inquire what has happened to these original proceedings before the Supreme Court?
original case before the Supreme Court, Lord, perhaps that was by the order annexed herewith, that was disposed of to take care by the respective high courts. my
Respective
lord.
High Court.
Yes, my lord. Only state of Arunachal, there is some problem because they misconstrued the order passed by the Honorable Apex Court. They thought that only on objection these are to be removed.
You can add the word convenience. Where is Mr. Gautam?
Mr. Chandran is there, my lord. In fact, this Honorable Court passed an order.
We may take up at 2 o'clock.
Lordship.
Pass over.
Item number 83 to 88.
My lord, in pursuance to the order dated my lord 8/9/2022.
Mr. Mahanta.
My lord.
Other councils are not there. Huh? Now we have received the report from.
District Session Judge, District. Yes.
Would you like to have copies?
Yes, my lord.
That we last. Therefore, we have not even opened the seal.
Yes, probably it is seal cover, my lord.
It is sealed.
Seal cover.
So we'll direct the Registrar General to
My
open
lord.
the seal and provide copy to all.
My lord, definitely.
As per the order dated 8/9/2022. Done a district judge. District and sessions that seem to care submitted a report. Survey report. The sealed cover.
So it will be
Registrar General is directed to take out, to open the sealed cover and prepare copies to be handed over to, and the same may be furnished to all the learned advocates.
Mine.
This group of PIL.
Mine.
When do I keep it?
Well, at least 3 weeks, we might need to file an affidavit also.
No, you can't question this. Okay. You can't question.
I will not question, but stand
You are a state government, isn't it?
to indicate our stand, my lord.
We don't want your stand. Your stand is not required.
My lord.
On the contrary, ask your chief warden to assist you in person in the, though we have not seen it.
My lord.
Ask your officer to remain present.
My lord, definitely.
after 10
No
days.
affidavit will be permitted by the state. How are you concerned? This is PI. On the contrary, you should take a course which you are not taking.
We are
Therefore,
taking
they
up,
are here.
my lord.
We'll see, Mr. Don't be in a hurry.
After 10 days, man.
If the things would have been, as you are trying to portray this PIL, will dispose it of. We'll close the proceeding. I assure you.
Just for your lordship.
If everything is goody.
In the meantime, my lord, we have declared entire area as national park, my lord. But for 1% of area.
Sir, counsel,
My lord.
I have also burned my courts in such matters
My lord.
when I was there at your place. Because I was not a counsel. I was the counsel for the government. We always do our best.
My
But implementation is more important than declaring national park. We don't find fault with your officers at all.
My
Only thing is that they will have to act upon.
true, my
You have acted upon. Therefore, why do you need any evidence?
my lord.
If we feel that after looking at the report, we have also not seen. If we feel that no, some stand, but one thing is certain, that be ready for what is the stand of the government to, if at all, if at all there is anything,
My lord.
you will have to come out with the solution.
True, my lord. I will definitely do
You are our, you are guards.
I will definitely do that, my lord.
When do I keep it?
As per your lordship convenience.
Let it come on 17th of November. Thursday.
Oblige, my
Next.
Item number 89.
May I please, your lordship.
Yes, Mr.
Yes. This PIL will raise an issue with regard to the lord setting up a bricklane, my lord, violating the norms, my lord. In fact, my lord, the deputy commissioner, my lord, has supported our case, my lord, indicating that there has indeed been a violation of the norms, my lord. The population norms, as well as, my lord, there need not be any school or, my lord, a religious institution in the vicinity. My lord, the guidelines, lordship will find, my lord, at page 25, my lord. Page 26 is the relevant portion, my lord. Page 26, my lord, the location, my lord, location of land. Both, my lord, 4.1 and 4.2 has been violated.
Where are you reading, Council?
Pardon, my lord?
Where are you reading?
My lord, page 26, my lord, the guidelines, my lord. Location of the land, my lord.
Who is to oppose you?
Well, the deputy commissioner in his affidavit, the other, my lord, the respondents, my lord, have tried to, my lord, say that, my lord, this have not been violated.
No, I say who appear for that.
Appear, my lord, the private respondents, my lord.
Also, in this matter, I appear for the pollution board. Already we have filed our affidavit, which has been replied to them. And as per the inspection that we have done, it is following all the norms that are mandated. So there is no violation as such, and all the inspection has been done. And that apart, they have been claiming that the public hearing hasn't been done. That public hearing has been duly done as per the said norm.
So we'll fix it for hearing. We
My
have to hear this.
My lord, lordship.
So who else is there for the private? Because they have filed.
Yes, my
their
private
opposition.
respondent, one Mr. Hussain, my lord, Mr. S. Hussain will appears, my lord. The last occasion, so they took time, my lord, to file a reply to my lord, the affidavit of the deputy commissioner, my lord.
That is right.
My lord, today, of course, no, I'm not seeing anyone, my lord.
We'll pass it over. Otherwise, he will not come to know.
My lord.
We'll pass over, take up at 2 o'clock.
My lord. Tip.
Matter number 90.
Pass it over.
Matter number 91.
Lordship, this excise department, they have to file affidavit. In the last
Lordship-
2 occasions, they have taken time to.
Lordship, the affidavit is ready. It is sent for signing of the deponent, Lordship. Kindly 7 days time may be granted.
Next week.
Last occasion also, the same sentence have been repeated. That it is
Next
signed for
week.
sign.
Next Tuesday.
Next, Lordship.
Next.
Right.
Matter number 98.
It was the David wrote it. Just it said by to the direct take the report of service to the sole respondent expert appear order dated 1/9/24. It's just 7th of September, the 7th of November. Next,
Item number 99 to 105.
May please, your lordship. Lordship, our item is 99, 103 and 104, lordship. We are required to file additional affidavit, lordship. 3 weeks time may be allowed.
next,
Obliged.
Item number 107.
Temporal respondent.
so that appears for the appellate.
Yes, sir.
You wait for it. Not to take pass over.
Please, it, madam.
Oh, our time.
Where is Mr. Majmudar? See, we can't grant you 4 weeks time. You can understand puja holidays and all that. But then, see, we have categorized into A, B, C, D, E.
Yes, madam.
You, as soon as you, by way of interim relief, you pour in the details. Otherwise, if we adjourn it for 4 weeks, means this bench will not be able to take up the matter.
Yes.
Virtually.
Well, this is a letter of 21st of October, my lord. So already, my lord, 10 days have been passed, my lord. So another.
This is what I am telling you. We
Yes,
can't grant you 4 weeks.
Yes, my lord. That I understand, my lord.
Out of question. You have to speed up. Now no puja is there.
Yes, my lord. That I understand, my lord.
Can give you some reasonable time. Otherwise, you obviously. They must have done some work.
Yes, my lord. In fact, my lord, kindly prepare the annexure 4 of this instruction, my lord. That is the minutes of the meeting, my lord. Well, we have already traced out the record, my lord. Record of 2005. Serial number.
My thought that we have seen already. The question is, how many candidates are there? Or how many persons are there?
Yes, madam.
If you finish 100, give us 100.
Yes.
so that we can bifurcate them. Why do we need 4 days time? We are not asking for some inquiry report. These are on the factual. You should have done it yourself. Instead of that, we are suggesting this to you. Mr. Majmudar has gone for lunch or is arguing motion somewhere?
No, Malab, he went to doctor school, Malab, for some reason, Malab. So he's on his way, Malab. He's about to reach, Malab.
You are absolutely correct. You have shown us the correct thing. 21st is there.
Yes, Malab.
We can't adjourn it beyond 9th of November. Otherwise, I will not have any time to complete the series. Once I start, before I demit my office, I have to complete the series. You understand?
Yes,
That
yes,
is the,
yes, Malab.
I'm
Yes.
making it
Yes, Malab.
eloquent.
I
There is nothing
understand,
to
Malab.
hide.
So in the meantime, Malab, we have whatever we have completed, Malab, we will produce before December.
Naturally, you have to start that. Your committee may continue the work.
Yes, Malab.
We may continue the work here. By 9th, some substantial work must be completed by the. If you have taken holidays on puja days, then work more. We also go after 7 every day, even though my house is just at a walking distance. We all work. You people work up to late night at your offices. Your IAS officers should help us for the cause. Just as you have appropriately constituted a committee who have authorities with them, inherent jurisdiction is there. It is good thing that you have done. We'll keep it on 9.
Yes, Malab.
Not further. And by 9, whatever you have done,
Yes, Malab. We will
you
produce
place
it,
it
Malab.
on record.
Yes, Malab.
And you place it by 7, so 8 we can utilize for going through it.
Okay, by 7 we will please.
7th is Sunday.
9.
No, 7.
8 is a holiday. So
8 is holiday.
8 is all.
Scheduled.
So this matter will come at 9.
Pardon, sir?
9. On
Yes, 9. We'll record it. Otherwise,
Yes.
every one of you may not forget, but we have tendency of forgetting. Heard Mr. Write names of all the non-senior counsels. Mr. Das, Mr. U.K. Nair, R. Kalita, senior, so both the senior, and U.K. Nair, senior advocate, Rubin Bayer, and right name of the government council. You ask Mr. Majmudar to be here.
Yes, Malab.
So we are adjourning the matter. I would like to appraise him himself.
Yes.
Then counsel for the government has placed on record the communication addressed by Secretary to the Government of Assam in Department of School Education dated 21st October 2022 on record along with the necessary enactors. It appears from the same that a committee has been constituted pursuant to our earlier order dated 26/9/2022. The request for 4 weeks time cannot be considered. It is a last chance SO to 9th of November. Meanwhile, by 7th of November 2022, the committee shall, by way of an interim report, submit all details which they have worked out as per the earlier order on record of this group of petitions.
Right.
8, 10 to 9. We'll take up at 2 o'clock, so all of you can adjust the next.
Item number 82.
Malo, one accommodation, item number 1 in the main list. Can it be taken next week, Malo?
Somebody has already mentioned.
Somebody mentioned.
Yes, some difficult.
It has already been mentioned in the morning.
Item number 1. In the main list. Hearing, Malo.
Oh, hearing, man.
Yes, some accommodation, Malo. Next week I will do it. Part 2 list.
Keep it next week. In the main board. In the main board. Those who agree will, it should be shifted to main board. We are shifting it to the main board, so you will also get it in the main. So we can also prepare our.
Yeah.
Follow.
Number 82.
Yes,
State
Mr.
of
Raj.
Arunachal Pradesh is required to, my lord, clarify the issue because they have initially misunderstood the order passed by the Honorable Appellate Court.
No, they have conveniently understood, not misunderstood. There is a difference of
Well,
convenience.
we have received the status report as of 25th of October. I have given a copy, madam.
Sometimes, Mr. Das, it is conveniently understood.
This Honorable Court also was pleased to pass an order clarifying everything.
When are you going to complete this, Mr.
My
Goswami?
lord,
Once
they are seeking 2 months' time, my lord, second page, madam.
Yes, that is what we are saying.
My lord. I'm handing over a copy. There are 26 districts in all. 13, my lord, completed. And then again, 13 is left up. Survey is going on and thereafter, my lord, reports will be produced before the state level committee.
Now, suppose if we grant you 2 months time from
Fine.
25th of October means 25th of December,
My
then you will say that it is winter and snow and all that. So it will go up to
my
March.
lord, I have to act on the instruction from them, but I will try to insist that the
No, we are directing you to do it within 1 month. Out of question. You are bound by your instructions. We are not. This is pending since long. What are you doing since 2018? Unnecessarily, Supreme Court has disposed of the matter and these matters are pending in every high court because of lethargy on part of the respective government. Either the reasons you cannot spell out are there or you don't want to do it.
no, my lord, after the given date, my lord, 2009 September, my lord, no new constructions are there.
Mr. Goswami, we will record a note of appreciation for the work that Arunachal Pradesh officers are doing. 2 months out of question. Start from today. Tell them.
My lord, survey is going already started.
Survey. What survey? What survey?
My
Only
lord,
demarcation is there. Have you given them notices for eviction?
my lord, what has happened, my lord, in our state, my lord, there are many defense installations, my lord. Some of these religious structures are in defense area,
Sir
some are
Goswami,
in private.
remind your officers of an anecdote which happened in the Lok Sabha.
My lord.
That if there is a wish, there is a way, otherwise there is survey. Madhu Limiye made that statement long ago before the Lok Sabha. If you have a habit of reading,
Right.
you must be knowing it. But tell your officers that they cultivate wish, otherwise
I will.
don't compel us to issue so much contempt notices. Because if every government does, Arunachal Pradesh doesn't have any special status. 2 months, every time 2 months, 1 month. You have your revenue officers in every district which you have enlisted. This survey can be over within one week. You have tehsildars everywhere.
My lord, it is not incorporated in this report, but my lord, in the last 5-6 years, my lord, 4 or 5 new districts have been called out, my lord. That may be
But
one reason.
see,
I'm
this-
just, my lord, submitting, my lord.
In Assam also, as a matter of fact, 4 districts are called out. Even we have also, Mr. Das clients are also faster in appointing district judges.
Yes.
That happens.
Right.
For example, now they may one day come, they may feel that no, this small district now amalgamate. So what will they do? They will wait for everything. We are in era of now computers. Survey is done by computers, majority cases. They don't want to do it. That is what our impression is. Every time they come out with an instruction letter to you. You do one thing, we are keeping this matter on Monday because we have other PILs where you are appearing on Monday.
Yes, ma'am.
Inquire for them, which is the least time that they would require for this. We will not grant more than 4 weeks. Tell them.
That can,
We don't want to be harsh today, but on Monday we will pass that direct.
ma'am.
If Nagaland can do it, if Mizoram can do it,
No,
Assam
Assam
can
has
do
also
it.
done. Milo. Assam has done substantially.
Yes, Mr. Kalita, what is your position? Sir? And yes, Ms. Thiru? But that if we hope and trust that the affidavits give the correct picture, Mr. Kalita. So if this can be done, why not Arunachal?
Yes, ma'am.
So
They
Goswami,
took a view initially that if some complaint comes, then only we can move in. That view was taken. So
Mr. Goswami, you will have to talk to your officer. We will not grant you more time.
I'm in touch, my lord. Kindly keep it on Monday, my lord.
We don't like to be harsh, but in such cases, unnecessarily, these are all, petty cases according to me.
Ma'am.
What mind we have to apply or what mind you have to apply as counsel? So what which question of law is to be deliberate? Unnecessarily, such type of matters occupy our time and mind both.
Exactly.
the directives are already there. Implementation is only.
Next, at the request of Mr. Goswami, learned additional Advocate General Arunachal Pradesh as a last chance adjourned to
7th, ma'am.
7th of November. Next.
Obliged.
Matter number 89.
Lordship, I apologize. Unfortunately I missed the matter today, Your Lordship. Lordship, matter can be fixed for admission hearing, Your Lordship.
At the request of the next.
Obliged, Lordship.
Obliged.
Matter number 90.
Lordship, in this matter, the pleadings are complete. So therefore, we kindly be fixed for the hearing. I'm appearing on behalf of the state appellant.
You
State
appear
of
for the
Sikkim.
Sikkim.
Yes,
State of Sikkim, you have.
yes, Lordship. I'm appearing for the state appellant. This is the service matter, Lordship.
Who is opposing you?
These are there are mainly is a respondent number 1 to 10.
No, but who represents that?
I don't know. There was the lawyer, senior lawyer. I do not know, Lordship.
Is he from Gangtok or is from Gauhati? Mr. Prasad?
From Gangtok, and then a lawyer, local lawyer also, they must have engaged, Lordship. So, but I have not inquired much about that. But they have filed their affidavit of reply in response to the writ appeal. And we have also filed the rejoinder to that effect. Now the pleading in that sense is over, Lordship. It's in a short, Lordship.
Now, when did they enter the services of Sikkim government? On
This
which
is-
date?
2008. They are saying the grade 1, junior grade 1. They
No. What was their initial date of entry?
2008 initial date of entry is, Lordship. In the initial entry, there was no issue as such.
No, we are asking you for the date of entry.
date of entry 2008 in the post of but initially as a LDC, as a clerk,
No, that you are referring to 8th of May 2008.
yes,
That is for, because there says that their seniority should be fixed from 8/5/2008.
what is the case, Lordship, if I may say so in a very precise manner. So what was the crux was that initial there is no dispute as such, but the main post is on the accounts officer,
Yes.
officer in the junior grade. From the grade 1 to junior, subordinate service to the gazetted label. So in that they say that they were given an officiating promotion in the year 2008, which is there, the Lordship, if I draw there, 2008. Officiating with the caveat, with a clear, without any ambiguity, the terms and condition that this is not a permanent promotion.
It was ad hoc.
Ad hoc. It's
Ad hoc.
purely an ad hoc.
Your case is it was ad hoc.
Ad hoc. So you'll not have a seniority or not a confirmation as a substantive promotion to this effect. Without even hesitations, no protest, they accepted that order. Then they continued on that. And they confirmed. They were confirmed as per the procedures of their own service rule, cadre, finance rules, 1980, amended 1986. There is a selection committee process. That whole selection process has been commenced, and then there all that criteria, everything has been sorted, and they found to be qualified. Then that was in 2013, they were confirmed in the substantive posts of account officer. But prior to that, there was another cadre, there was a direct, these are promotees. There was a direct cadre appointment of a direct employee in the year 2009 for the post of account officer with a direct entry level. Now, after lapse of nine years or so, a still claim has been made. Now for the next level of a future promotion. Then they suddenly came after 10 years or so before the court. They're saying that, look, there was a vacancy. Had we been promoted in the post of accounts in the year of 2008, where we were given an officiating, we would have been senior.
Therefore,
the single judge.
Madam, therefore I was asking you this question.
Yes, Lord.
See, there are two channels in the accounts officer.
Yes, Lord.
One is direct recruit.
Yes, Lord.
Which, as per the factual background of the matter, has taken place in 2009 for the first time.
Right.
As far as we are concerned.
Yes, Lord.
They entered state services before 2009.
Before that.
Now, because now there must be quota system.
There was for the gazetted label, because they were
there was a quota fixed for direct recruit and promoting.
And the yes, Lord. There was for a promotee.
For the promoting.
Promotee, yes.
Now, what was the quota between direct recruit and promotee?
That was a 50-50.
So 1:1.
1:1.
1:1.
They say that it's a
now only for a minute.
Yes, Lord.
Hesitate because it was not clear from the judgment.
Right.
I have not gone through prelims, but I have gone through the judgment.
Yes, Lord.
The question is that the question of officiating promotion
yes,
can arise on also for the post which were not filled in directly by you.
Yes, Lord.
So, meaning thereby, if there are two posts were vacant in 2008, for example, or 2007, instead of filling one post by direct recruit and another by promotion,
yes, Lord.
because of some reason or the other, say administrative exigency,
yes, Lord.
You gave officiating promotion to two.
Yes, Lordship. There was a yes,
Now-
2000.
Now, I will come to dates later.
Yes,
Now, the question would be that if the quota is to be maintained,
yes,
then as per their inter se seniority of the promotees,
yes,
even though if he is promoted as officiating accounts officer, the fact remains that he had gone in the feeder post as per the promotion rules. One of them.
one. Actually, the promotion has been made because there was for many years, as Lordship has said rightly,
There was a
for
stagnation.
some reason, direct recruitment has never taken place earlier for some reason.
That is what I
So therefore,
visualized.
only then the exceeding the direct promotees quotas, there was a hardly no vacancy in actual fact. So the promotees have been continually, they have been availing that.
That is what has
facility, all
happened.
that.
You yourself have created
Yes.
this problem.
Therefore, 2009 for the first time held, and that here the issue is now, they should have agitated then, not it.
No, that will examine.
So that
separately.
has to be examined. Then after lapse of that was a completely topsy-turvy of the settled principle of law. That's
We'll have to hear the other side also.
yes. Then it's
Ultimately,
basically seeking a
our
retrospective.
subject to hearing both of you.
Yes, gotcha.
The government of Sikkim has exceeded the promotee quota.
Yes, promotee quota in sense exceeded,
is
and the
exceeded.
direct has never been.
Therefore,
gotten.
you have used therefore the state has very candidly used the terminology of officiating promotion. There is nothing like officiating
There is
promotion.
nothing. What happened, Lordship, here, they have given, but with a very clear terms and there. This is not the substantive. There's Lordship will see that if I may draw the attention of the Honorable Court, that order, the officiating order of 2008, if I'm taking time of the Honorable Court.
There is no, we are investing this
Yes.
time.
Lordship may kindly have a look at the page number 103. Lordship has got that?
Yes, yes.
Yes. So Lordship may kindly have a look in that. The above officiating promise shall be subject to the following condition. The officiating promise shall not confer any right for regular promotion and shall not be counted towards seniority. The regular promotion shall be made on the recommendation of the State Public Service Commission.
Now, this is second limb of the argument.
Yes.
You,
then Lordship, then the next.
I have noted from page number 2 and 4 because it is.
Yes. Then Lordship, next page.
Hmm.
2013, that is a 105, Lordship. Page 105. So this is there.
Now, for officiating promotion, you did not go to APSC.
A selection process for officiating, therefore, it's a purely a temporary.
Therefore, you did not go to
No,
the
that
Public
rules
Service
have not
Commission
been
is not
applied.
necessary.
Yes, Lordship. Selection process as per the
We'll
rule
look
that has
into it.
not been
We'll
adhered to. Then the 2013 process has been adhered to, then they will come. End of December.
You come from Gangtok or you are?
I come from Gangtok, Lordship. I'm sorry, I was late in the morning.
No
I
problem.
apologize. I come from Gangtok. Yes, Lordship. Yes,
You intimate him because
we will do so. They are very particular. In fact, I don't know. It looks like a very candidate, off the record. The client must have abandoned them. Looks like. Otherwise, they are very careful as far as I know them.
that is always the advantage of becoming a counsel for the government, man. You please inform him.
I'll do so.
Which date would be convenient to you?
I will do so.
Which date would be convenient to you?
December and Lordship, I have some matter fixed in
Then you come
November,
after
slightly
January.
tight, Lordship. I'm tight. I have some matter in the Supreme Court. Then some matter already
Give the
fixed
date.
sometime end of December.
It may not be. We'll put some date.
Fixed date 22nd November.
22nd November.
December.
We are closing from 22nd.
Slightly before that, convenient to December, Lord. Before. Any date convenient to the spot, Lord.
If you ask for 22, even the court and I will both close together. Any date that you want. We are not.
December, Lordship.
Because you are coming from outside.
Yes, Lordship. December 19, Lordship, it's a convenient. Because it's a short matter, Lordship. It may not take much time. It's basically a retrospective.
Better have your date in the first week of December if you can.
First week, Lordship, I'm slightly occupied.
But after December, I am not occupied. Therefore, I can't give you 19.
will not take much time, Lordship. This is a short, whether retrospective promotion can be granted or not, that is what.
Give date of your, give date. Next.
Item number 107.
I'm much obliged, Lord.
May I please your lordship. Pursuant to your lordship's direction, while the mediation was held, now I am told that in one sitting, both the petitioner, appellant and the respondent appeared. And the second sitting, my lord, the respondent didn't turn up. And during the mediation also, the respondent, he was, what I am told is, he was more on getting the flat and other properties, my lord. That is what I am told, my lord.
Mr. Counsel, any possibility still we are hopeful?
That is what also, my lord, I also told my client that because with that hope only, my lord, he came for the second time, my lord. And the respondents, my lord.
What are your instructions?
The appellant does not accept the respondent. They have some quiet in the mediation center because so the respondent can't turn up. So he has been quarreling with the respondent.
Quarreling?
Quarreling is some debate in the.
This is result of the debate only that you are here. You have to find out a way out of it. Then you argue the matter. What else? It can't help.
No, the lordship, my lord, the appellant hearing is agreed by an impugn order.
No, but what is the evidence on record? Because this is an appeal ultimate.
No, this is an appeal against section 24 interim maintenance, my lord. No evidence has been taken, my lord. And
Did you appear before the court?
Yes, my lord. It was an inter-party, my lord. Before the family court, an application was filed under section 24, my lord. And
you find in the order that it is opposite party is absent.
That is my lord. I think it is in the mediation report, my lord.
No. Impugn order.
Now, absent with steps, my lord. The petitioner is present, opposite party is absent with steps, right petition number so and so.
What do we understand from?
So with steps, my lord, the petitioner, opposite party was not represented, my lord, but petition was filed, my lord. But an objection was also filed in this instance.
It is neither here nor there.
That is.
It is neither here nor there.
Yeah, now objection was also filed, my lord. Now the my respectful submission before your lordship is, my lord.
No. Did the hearing take place?
My lord. May I read the impugn order, my lord?
That is what we are also doing.
Yes, my lord. Page. The petitioner is present, opposite party is absent with steps, right petition number so and so. This is an application under section 24 of the Hindu Marriage Act 1955 filed by the petitioner Srimati so and so, praying for maintenance, pendentialite and cost of proceeding. The petitioner has stated that the petitioner and the opposite party were divorcees and the earlier marriage of the opposite party broke down with his earlier wife, namely so and so, in the year 2011. The petitioner got married to the opposite party on 12/6/2015, according to the Hindu Rites and Customs at Kamakhya Mandir, Gauhati. She has stated that till August 2015, the petitioner and the opposite party lived together in the Santigram housing complex, Beltala. She has stated that before the marriage, the opposite party disclosed to her that he usually used to stay outside from his home due to his work in Lower Assam region like Borpeta, Dhubri, Nagarvera, etc. She has stated that after the marriage, the opposite party had stayed for about 2 months with her, and thereafter she used to stay away from her in pretext of his project work, and she only get chance to meet him for about 7 days in a month when he come to his flat at Beltola. She has stated that the father of the opposite party expired after some months of their marriage, and thereafter he stayed in his house with his mother in Shillong. She went to Shillong with her parents and others to attend the Tiloni ritual, but the opposite party showed various unnecessary reasons, did not allow her to stay in his house at Shillong, and she was compelled to leave and was not allowed to attend the Shraddha ceremony of his father. She has stated that even when she was ill, the opposite party did not come and also did not take care of her and provided any money for her treatment. That the electricity bills, money to purchase gas cylinders, society dues, paper bills, etc., are paid by her from her financial assistance provided by her parents. She has stated that she is an unemployed lady and has no independent income sufficient for her to maintain. She has stated that the opposite party is a habitual drunkard. The opposite party did not want to make physical relation with her and always used to come home late at night at about 11 p.m. She has stated that on 13/3/2016, the opposite party, along with his mother, went to Shillong, and thereafter he did not come to his Gauhati residence for about 1 year, 8 months. She visited the house of the opposite party in Shillong in November 2016, but his mother misbehaved and quarreled with the petitioner and asked her to be separated from her son. She has stated that the mother of the opposite party, through her maid servant, physically assaulted her and was thrown out from the house. The petitioner lodged an FIR before the concerned police station against the mother of the opposite party and her maid in Shillong. She has stated that the opposite party never paid any money to her for her maintenance. On 18/11/2017, the opposite party with his mother came to his flat at Peltola. She has stated that the mother of the opposite party is pressurizing her son to get him separated from the petitioner. The petitioner lodged an FIR on 30/11/2017 before the Botista police station, which was registered as case number so-and-so under section 498 IPC. He has stated that due to physical and mental torture by the opposite party and his mother, she filed a domestic violence case before the Chief Judicial Magistrate, being numbered as Miss DV case number so-and-so under section 12 of Protection of Women for Domestic Violence Act 2005, which is pending before the Judicial Magistrate First Class Kamrup at Gauhati. And in the said DV case, the court granted 4,000 as ad interim maintenance to the petitioner. She also filed another case before the court seeking restitution of conjugal right, which is pending before this court. He has stated that after filing the domestic violence and restitution of conjugal rights case, the opposite party filed a divorce case before this court, being numbered as FC civil case number so-and-so, and is pending before this court. She has stated that the opposite party by profession is a mechanical engineer, but presently he is doing contractual work in various government departments of Assam and is doing big project work. Besides, he and his mother have big houses besides 7 houses which they have given on rent to tenants situated at Shillong. Therefore, the petitioner has prayed to direct the respondents to pay maintenance penalty at the rate of 30,000 per month for herself. The opposite party has raised objection in the prayer of the petitioner. He has stated that the petitioner has applied to a marriage bureau and advertised in the Assam Tribune that she is highly educated with B.Ed and MS IT degree and working as teacher, and her marriage was solemnized with the opposite party on 12/6/2015. He has stated that he is an engineer by profession and used to work in different organizations outside Assam, but returned to Assam about 25 years back due to the ill health of his father. That for his earnings, he tried to do some business but failed due to the after effect of the Assam movement. Thereafter, he started to work as a freelance consultant and lived by earning consultancy fees and was associated with certain state government contractors. But all the projects had to be shut down since last 2 years due to non-payment of bills of government of Assam. He has stated that both the properties in Shillong and the flat at Gauhati belong to respondent number 2, over which he has no claim. He has stated that the petitioner is a quarrelsome person and unruly by nature and never paid heed to any kind of suggestion, cooperation, and discourses relating to their married life. And on second day of marriage, he threatened him and his parents that they should now onwards abide by her whims and demands and kept on blackmailing that she will go to the police commissions, etc. if she will not abide by her and give a share of the property. She always used to abuse and threaten him and his parents with. Yes, ma'am. my lord, no evidence was left, my lord. But what I could find, my lord.
Because Mr. Das, the fact remains that this is a 24 petition.
Yes, my lord.
Other proceedings are pending at large before the competent of
Yes, my lord.
court.
Yes, my lord.
This is just like considering an appeal from order.
Yeah.
Now, no evidence is left that he has any income. The learned family court judge had to write that there is no evidence.
Yes. Now, my lord,
You are a mechanical engineer.
yes.
Now, even if you say that you are not having any job, a mechanical engineer wife, 4,000 to pay as domestic, but there is a judgment of the Supreme Court which is rightly relied upon. And I think recently, last year also, one more judgment has come which says that maintenance in domestic has to be considered, but while computing, it is not to be deducted from what is. Now, in 22, 8,000 rupees is less than reasonable.
No, I fully appreciate, my lord, what has fallen from your lordship, my lord. And my lord, we have also filed an affidavit, my lord. This petitioner, my lord, appellant.
These are not writ petitions that you file affidavit and we take that
No, my
evidence
lord,
on record.
no, my lord. So what I pray, my lord, we have on affidavit, we have stated that his income is around 15 to 20,000 because he is earning by way of giving some consultancy service, and because of this COVID period, my lord.
Now COVID period is gone.
No, my lord, he was
Only
associated.
two of us are having mask. None of you have mask.
That some bills,
Now mask
some
is not necessary.
he was associated with some, my lord, consultants, my lord, because of non-payment of bills, my lord, that is also gone. So
You don't use any evidence.
there is also what I pray, my lord, let if your lordship, my lord, my
Therefore,
respectful
at the
submission.
most, we may expedite the trial of the.
Our lordship may, my lord, remand the matter. Let
No. Why should we
evidence be
remand?
adduced, my lord, before the.
Why should we remand any matter for 8,000 rupees? These are
that
not
is-
final verdicts. These are all pendency light.
Because
We can expedite the proceedings of the family suit.
our lordship may reduce it because initially the petitioner was paying 10,000, my lord. Now
Sir,
in the DVF,
it is less than what a contractual laborer gets in Assam.
my lord, there is, but your lordship.
Assam government, Majmundar, 9,000 you pay? 9,000.
Now, my lord,
Then
with all
8,000 is nothing, sir.
but with all respect, my lord,
If you
there
go
has
to
to be.
Fancy Bazaar and come back within
No,
half
my
an
lord,
hour, you will be out of 8,000.
In the impugned judgment, my lord, the learned trial court has also arrived at an
Mr.
finding.
Das, that you have to argue when you have adduced evidence and all that, not in air.
No, my lord, in the impugned
With great respect, as we more often appear in writ petitions, we argue appeal also in the same format.
No, my lord, in this impugned judgment, my lord, the learned trial judge have come to a finding that while deciding and maintenance have been considered, my lord. Now, in this
Therefore, we are asking you, did you adduce any evidence?
no, my lord, there was, my lord, from the, my lord, as the records have come, my lord. So from the lower court records, it can be verified, my lord.
No, you tell us.
No, yeah, as per my instruction, my lord,
There is
no
a
date
mention
was-
that there is no evidence.
My lord, no date was, my lord, I think it was fixed for adducing of evidence.
That is neither. These are all.
Because the records are there, my lordship will verify the records. my lord.
Anything else?
So, my respectful submission is that, my lord, the learned court below had committed a grave mistake, my lord, because on one hand, the court says that the income of the husband has to be considered while passing an order of interim maintenance. But in the impugned judgment, your lordship goes in, my lord, there is nowhere a whisper. It is only on the basis of assumption. The court has assumed that just because he is an engineer, so he is earning handsome, and so an amount has been awarded.
Naturally.
Now, we have
If you would have been advocate, the amount would have been more.
My lord, as per your lordship's direction, my lord, we have also filed an affidavit that income tax return and all those things. That because of this family, my lord, family problem, he had to leave his job, my lord. His father was bedridden. He came back here. Now the
Mr. Das, have you come across any matter of such type where husband really tells the truth of his income to a court?
That is why.
And we could have considered if you would have adduced any evidence.
Because, I think, my lord,
And we all know that the other side has still a right to file a further application for enhancement.
Yes,
even after divorce.
But, my lord, as the
If you want, we may expedite the proceedings of family court, so it may be finally decided, so this pending light may come to an end.
Well,
That much we can assure you.
4,000 we are already paying in the DV case, my lord. Let it be from 8,000 to 6,000, 10,000 per month, my lord, we will pay, my lord. So in total, 50% of the income, my lord.
Let us see. These are the two main broad contents.
My lord, that is the
Heard Mr. Swan, HR, for the appellant and SR Gogai, London County. For the appellant. For order.
For a moment, regarding that salary certificate, at page 47, my lord, at which, although it was not placed before the, my lord,
Forget it. Forget it.
yes, Lanet trial court, my lord. But in appeal, we cannot bring new things, my lord, but
forget it.
It is there, my lord, that she was working in some
It has to be proved, sir.
Hello?
Unfortunately, you were not advisor when the matter was at trial court.
That is, my lord.
I could make out that.
In the appeal also, my lord, it was filed by some, my learned brother.
Nothing
I
can
came in
be
later,
done.
and this petition, but this certificate is there, my lord, that she was earning, my lord, she was
That
working.
is what
as
I am telling you, that this is not a writ petition.
That is what, my lord.
You have to prove that certificate.
My humble prayer is, my lord, lordship will make it 10,000, my lord, we will
We have
pay.
noted them.
And also, my lord, will expedite the matter, my lord.
Mr. What have you, what do you say about 10,000?
On paragraph 20, page 20, we have admitted on 2016, he is paying 10,000 as maintenance. And in the divorce,
No, my lord.
paragraph 20,
We said
page
that
20.
we were paying. Initially, we were paying 10,000 to her. That is what.
And he has also given 70,000 rupees to the respondent. Paragraph 20,
The
page 20.
answers are heard finally. So finally. For order. Next.
And even she is residing in the our property. Ma'am.
Next.
I am obliged, ma'am. I am obviously obliged.
Next. Anybody is there, ask them, then we will continue. If nobody is there, we will open up. Mr. Majmudar, we have adjourned it to 9. Our idea is, your colleague must have told you, we may not wait for the final outcome. In this sense, all the cases, whatever they have covered, produce it by 7. So we can look into it, and if we can sort out, we can go ahead with the matter. So at least for those persons, the matter can be put an end to. Do you understand?
Whatever they have done till now, till the 6th, I'll place it on the 7th. But only one prayer on the 2 on the 10th.
9. 9th at 2 o'clock.